I will discuss this morning the Philippine island territories in the West Philippine Sea. What are the islands in the West Philippine Sea that are part of Philippine territory under Philippine sovereignty? I'm referring to Scarborough Shoal, that's Bao de Masinloc, and the islands in the Calayan Island group within the polygonal lines of PD 1596. We're claiming the high tide features. Why are we saying that these islands are within Philippine territory under our sovereignty? When you look at the Treaty of Paris lines, the Treaty of 1898, you will see here that Scarborough Shoal is outside the line. And the islands in the Calayan Island group that we claim are outside the Treaty of Paris lines. So why do we say that these islands are within Philippine territory? The greatest misconception in Philippine history is that many of our public intellectuals, even legal luminaries, are saying that Philippine territory is limited to the islands within the lines of the 1898 Treaty of Paris between Spain and the US. This is factually, legally, and historically false. And this has misled our people and the rest of the world as to the true extent of Philippine territory. For example, former Solicitor General Estelito Mendoza wrote in an article that he published in 2009 in the Philippine Judicial Journal, that's a journal of the Philippine Judicial Academy under the Supreme Court. He said that it must be remembered that the Calayan Island Group came to be part of the Philippines only upon the enactment on June 11, 1978 of PD 1596. It has never, through the centuries of its existence, been regarded as part of Philippine archipelago. And this has been widely quoted by the Chinese. They're saying, see, the Scarborough Shoal and the KIG are not part of Philippine territory. Even your former Solicitor General said it has never been part of Philippine territory. And you have also Father Bernas, the Dean of the Ateneo Law School. He wrote a column in the Inquirer in 2012 that in the Spratlys, we are claiming land areas that are outside the lines drawn by the Treaty of Paris. He said, we cannot justify that under treaty law. It's not part of the treaty. The challenge for us is to be able to justify our claims under the present state of international law. And you have former Senator Enrile, Juan Ponce Enrile, who is now the Chief Presidential Legal Counsel of President Marcos Jr. Recently, just last May 2021, he said, alam mo, yung Scarborough Shoal, hindi sa atin yan. Squatter lang tayo doon. It's outside the Treaty of Paris. All of these statements of our legal luminaries claim that Philippine territory is limited to the islands within the treaty lines of the Treaty of Paris. And this has misled not only Filipinos, but also China. And Chinese Foreign Minister Wang Yi, in a speech at the CSIS think tank in Washington, said, there are three treaties that stipulate Philippine territory, the 1898 Treaty of Paris, the 1900 Treaty of Washington, and the third, the treaty with the British of 1930. Areas in the west of the 118 degrees east longitude do not belong to the Philippines. The Spratlys and the Scarborough Shoal are all in the west of 118 degrees longitude. This is the 118 degrees longitude line of the Treaty of Paris. This is the western side. Scarborough Shoal is outside. The Spratlys is outside. So you see, he said, before diplomats from all over the world, Scarborough Shoal and the Spratlys do not belong to the Philippines. This is totally false, and it is time to correct once and for all this misconception which has misled so many people. We start with the 1935 Constitution, which defines Philippine territory. It says Philippine territory refers to the territory ceded to the U.S. by the Treaty of Paris of 1898, together with all the islands embraced in the treaty concluded in Washington. That's the Treaty of 1900. So here you can see a hint already that Philippine territory is not limited to the territory ceded by the Treaty of Paris. It also includes islands embraced in the Treaty of Washington. The treaty is the treaty concluded with the British, demarcating our boundary in southern Philippines, between southern Philippines and British North Borneo. Now, if you drill down to the treaties, the 1898 treaty says what was ceded to the Philippines by Spain to the U.S. Was the archipelago known as the Philippine Islands, lying within the following lines. That's the Treaty of Paris lines. But the Treaty of Washington later clarified 2 years later that the cession of 1898 included any and all islands belonging to the Philippine archipelago lying outside the lines of the Treaty of Paris. And in the treaty with the British of 1930, the term Philippine archipelago was defined as the territory acquired by the U.S. in the Treaty of Paris of 1898 and the Treaty of Washington of 1900. So it's clear that Philippine territory includes any and all islands belonging to the Philippine archipelago lying outside the lines. So the question is, what are the Philippine islands lying outside the lines of the Treaty of Paris? Well, first of all, the term Philippine archipelago must be understood as the term was used in the 1898, 1900, and 1930 treaties, because the term archipelago has now a specific meaning under UNCLOS, 1982 UNCLOS. There must be a water-to-land ratio, that the water-to-land ratio must be anywhere between 1:1 and 9:1. But that is a technical definition of archipelago that came about only in 1982. Under the Treaty of Intertemporal Law, rights under a treaty must be evaluated in the light of the law contemporary with the treaty, not with reference to the law in force at the time the dispute arose or the time the dispute is decided. So the term Philippine archipelago should be understood to mean as understood by the parties to the treaties, the Treaty of Paris of 1898, Treaty of Washington of 1900, and the treaty with the British of 1930. It's not to be determined in accordance with the present-day interpretation of archipelago. Now, as a background, just to remind everybody, there are two disputes in the South China Sea, the maritime dispute and the territorial dispute. The maritime dispute was finally legally resolved with finality by the award of July 12, 2016. I say legally because it cannot be questioned anymore. That decision is final and binding. Vietnam, Malaysia, Indonesia recognize that award. It's only China that does not recognize that award. That award defined our exclusive economic zone, affirmed that we have a 200 nautical mile exclusive economic zone in the West Philippine Sea. It did not touch on the sovereignty issue of the islands. Now, the territorial dispute has remained because there is no treaty that regulates territorial disputes in Asia, and in particular in Southeast Asia. Unlike the maritime dispute that is governed by UNCLOS, parties to UNCLOS are bound by the dispute settlement mechanism under UNCLOS, which includes a compulsory arbitration. Now, in any territorial dispute, the first thing that you have to look at is the critical date. This is the starting point in any analysis of a critical date. Why? Because from the critical date onwards, anything that the parties do to improve their claim, improve their title, like building air and naval bases, bringing in civilian population to stay in that disputed territory, they will not count. The court will determine uh, who has a better right based on the facts and the law just before the critical date. Why is this so? Because the intention of international law is to prevent the aggravation of the dispute after the critical date is established. Because the intention of international law is to serve peace and stability in all regions of the world. The moment the critical date is established, you cannot improve your title anymore by bringing in troops there. That will not matter. That has no relevance at all to in determining who has a better title to the disputed territory. So, what is the critical date in the South China Sea dispute? Well, we have to go to the timeline. Uh, in 1734, Spain claimed the Spratlys and Scarborough Shoal in the 1734 map. This was affirmed in the 1808 and 1875 Carta General del Archipelago Filipino. No other country made a competing claim to the Spratlys or to Scarborough Shoal until 1933. In 1933, France officially annexed the Spratlys as part of the French Union, not as part of French Indochina. In other words, France claimed the Spratlys for itself, not on behalf of its colonies in Indochina. And that's very important because Vietnam is claiming the Spratlys as successor to France, and it cannot do that because France never claimed the Spratlys as part of Indochina, but as part of the French Union. If you are part of the French Union, citizens in that territory are French citizens at birth, can vote in all French elections, including election to the French presidency. But France, of course, after World War II, abandoned that claim. In 1939, Japan seized the Spratlys that Japan established a submarine base in Ituaba. That submarine base was used in the invasion of the Philippines, but Japan lost the war and renounced its claim to the Spratlys after the war in the 1951 San Francisco Peace Treaty. Now, in 1947, China claimed the Spratlys, but admitted at the same time that the Philippines and the French in Indochina also claimed the Spratlys. China also included Scarborough Shoal in its 9-dash line, but China had no name for Scarborough Shoal in that claim. So the critical date here is 1947 because that was the date when the China claimed the Spratlys and Scarborough Shoal, and at the same time, the Philippines, as admitted by China, also claimed the Spratlys and Scarborough Shoal. So the critical date is 1947. Any action by any state from 1947 onwards would not improve their title to their claim. It will have no relevance as far as the tribunal is concerned if the tribunal is asked to rule who has better title to the Spratlys and Scarborough Shoal. Now, as I said, the critical date is 1947. So all those air and naval bases that China erected in the Spratlys does not improve the title of China. And of course, the people that we put there on T2 or Pag-asa, because we populated that with the civilian population, it would not also matter because that was done only in the 70s. The critical date is 1947. Now, there are the 3 treaties that regulate Philippine territory is very important because of this principle in international law called Uti Possidetis Juris. Roughly translated into English, that means as you possess under the law, stay there. Now, UT Possidetis Juris was developed as a very strong doctrine in international law because if you look at the map of Africa and Latin America, you will see there that the boundaries of the countries are drawn in straight lines. They are drawn uh, in vertical, horizontal lines without regard to where those people live. For example, one tribe may be found on both sides of the boundary. So one tribe may be located in one country, and another part of the tribe, the same tribe, is in the next country. They are divided. But to prevent boundary wars, international law developed the principle of uti possidetis juris, that those boundaries are sacrosanct. The boundaries established by the colonial powers in their former colonies, as those colonies emerged to become independent states, they are sacrosanct and must be respected by all states, because the purpose of the law is to prevent wars. And to prevent boundary wars, you have to respect all the boundaries established by the colonial powers. And that applies to the Philippines. In our case, 3 treaties established our territory, all established by the colonial powers: Spain and the US for the Treaty of Paris and the Treaty of Washington, and UK and the US for the 1930 treaty demarcating our boundary in southern Philippines. So those boundaries must be respected by all states, and this is a very strong principle under international law. All states must respect those boundaries. So the question is, what are the islands of the Philippine archipelago that are covered by the uti possidetis juris principle? Because we can invoke uti possidetis juris if Scarborough Shoal and the Spratlys were part of Philippine territory under those 3 treaties. So we start with this map to establish that Scarborough Shoal and the Spratlys have long formed part of Philippine territory and are included in the 3 treaties. First, we have the 1734 Pedro Murillo Velarde map. This was made in Manila. You can see here Scarborough Shoal with the name is Panakot. The first name of Scarborough was Panakot. It's a Tagalog word for danger. And you have Los Baos de Paragua. Paragua was the old name for Spanish name for Palawan. Los Baos in Spanish means, in English means the shoals. So the shoals of Palawan, these are the Spratlys. This is an official map of Philippine territory in 1734 because of this cartouche. This is the symbol of the crown of Spain, royal crown of Spain. When you see this symbol, that means it's an official document of the Kingdom of Spain. In 1733, King Philip V of Spain instructed then Governor General Tamon, who was the Governor General in Manila, to make a map of Philippine territory. And in 1792, Alessandro Malaspina came to Manila. He was the head of the Spanish scientific expedition that was sent to visit all the Spanish territories all over the world, to collect specimens of flora and fauna, and to chart the Spanish waters. There was a competition among the great naval powers at the time. Britain sent Captain Cook to conduct a scientific survey of all the British possessions all over the world. And the French also sent their own expedition. That expedition also came to the Philippines. But in 1792, Alessandro Malaspina, as head of the Spanish expedition, came to Manila. And when he arrived in Manila, he went to Scarborough Shoal. Why? Because Scarborough Shoal became very famous in Europe when the British clipper ship Scarborough ran aground on the rocks of Scarborough in 1748. And after that, the European cartographers renamed Panakot as Scarborough Shoal because of that grounding of the British Clipper ship. So Alessandro Malaspina went to Scarborough Shoal because it was a very famous shoal, and he conducted the first ever hydrographic survey. That means he measured the depths of all the areas to guide navigators so that they will not hit the rocks of Scarborough and run aground, and just like what happened to the British clipper ship Scarborough. And so this was the instrument he used. It's called the plummet. This is a lead, heavy lead. You attach it to a rope and you drop the lead, and you can measure the depth of the waters. So he made a depth sounding. That was how they made depth soundings at the time of Scarborough Shoal. So this is the map. You can find this map in the Museo Naval de Madrid. It was the first ever hydrographic survey of Scarborough Shoal, 1792, and the Chinese didn't even know that such a shoal existed at that time. And this is the map of 1808. This was now made at the time when Spain had a cartographic office. They call it charting office at the time. Dirección Hydrografía. This is equivalent to our NAMRIA. They made the charts. At that time, they were not called maps. They were called charts because charts of the mode of transportation at the time was through ships. So this was an official map of Philippine territory as of 1898. And this is a map of the entire Philippines. This is the first part. And you will see here the survey of Malaspina inserted in the map. It's very unique because the rest of the map does not contain any hydrographic survey, no depth soundings in all the other islands. Only Scarborough Shoal had a depth sounding. Why? Because the director of this Direction Hydrography at the time was Joseph Espinosa, and he was an officer of Malaspina when Malaspina came here to Manila. So he was with Malaspina when Malaspina went to Scarborough Shoal. So when he became the director of this mapping agency of Spain, he inserted the hydrographic survey that he did with Malaspina. So this is the full map. And in the lower part of the Philippines, you can see already islands of the Spratlys being included as part of Philippine territory, but not yet complete because they were still surveying the area. Finally, we come to the best map, the last map of Philippine territory that Spain made during the Spanish regime. This is the complete map of Philippine territory. All the islands of the Philippine archipelago are in this map. So if you ask the question, what are the islands of the Philippine archipelago lying outside the lines of the Treaty of Paris, you go to this map. This is an official map of Philippine territory during the Spanish regime. It was issued in 1875 with a little correction in 1888. And you will see here also Scarborough Shoal with depth soundings. And you will see here the entire Spratlys forming part of Philippine territory with names and with depth soundings also. Because this map was made by Claudio Montero, a Spanish naval officer who spent most of his career in the Philippines. He was appointed as the chairman of the first Philippine Hydrographic Commission. And his job was to conduct depth soundings of all islands of the Philippine archipelago. So here you will see depth soundings in many of these islands, especially in the Spratlys. So this is the map. This is the holy grail of Philippine map, because this is the complete depiction of Philippine territory during the Spanish regime. Unfortunately, we don't have a copy of this map here in the Philippines. And we forgot about this map. But if you go to the Spanish Defense Ministry, you can download for free a high-resolution copy of this map. This is where I downloaded this map. It is an official map of Philippine territory as of 1875 during the Spanish regime. And it was also adopted by the US. When the US came to the Philippines, they had no map, so they adopted the map as a map of Philippine territory. So you will see here, War Department Adjutant General's Office, 1901, third edition, because the US adopted and reissued this map 4 times. So they only added the superimposed the telegraph lines, the cable lines, but exactly the same map. So you have the Spanish regime saying this is Philippine territory during the Spanish regime, and you have the Americans saying this is Philippine territory during the American regime. But we have forgotten about this map. It's like saying you don't have a title to your house and lot, because this is the title, our title to the Philippine archipelago. This is officially adopted by Spain and the US. Now, so it was reissued 4 times by the US government. So it was well known to the US military officers at the time, but we have forgotten this map. Now, if you look at the map, 1875 map, in the Spratlys areas, you will see here, this is the boundary of Philippine territory in the map. T2, that's Pag-asa. That's the largest island that we possess. And then this is Loita. We call that Kota. That's the second largest island that possess in the Spratlys. And you have here Ituaba, the largest island in the Spratlys, under the possession of Taiwan now. No? So it's a complete depiction, and you can see the depth soundings here. There are names with depth soundings. And if you look at Scarborough in that map, in the 1875 map, this is the Scarborough in 1734. This is Scarborough in the 1808 map, and this is now the Scarborough in the 1875 map with depth soundings also. So China has no map like this. I mean, in 1734 up to 1875, China didn't even know that such a shoal existed. Now, if you go to the Calayan Island group, this is PD 5096 drew polygonal lines. PD 5096 said, all the islands and the waters within these lines constitute Philippine territory. Of course, that went against international law because you can only claim as your territory up to 12 nautical miles. When this was issued in 1590s, in 1970s, the territorial sea was still 3 nautical miles, but we claim beyond 3 nautical miles as a territorial sea. So we had to revise this PD. We amended the PD, the Republic Act 9522, claimed now only the high tide features and the 12 nautical mile territorial seas to align our claim with UNCLOS, with international law. So if you look at the, again, the Spratlys in 3 maps, you have the 1875, T2, Loita, Ituaba, in 2 maps, and you will see here also Pag-asa. You will see here Kota, that's Loita, and you will see here Ligao, that's our name for Ituaba. And the boundary is here. This is the extent of our exclusive economic zone. The boundary is here. It's exactly like the boundary in the 1875 map. It included all the islands that we're claiming. The Vietnamese also made a map of the South China Sea, including the Spratlys. So they also included the polygonal lines under PD 5096. And it's the same if you look at the 2 maps, the 1875 and the Vietnamese map. So you have here T2 Island, that's C2 Island. You have Loita Island, that's Loita. And you have here Ituaba, and that is Ituaba. Now, after signing the Treaty of Paris, the Americans, of course, came to the Philippines. And when they reached the Cagayan de Sulu in somewhere here in Cebuto, Cagayan de Sulu and Cebuto, Mapon, Turtle Islands or somewhere here, the Spanish garrison, they refused to vacate. This map really was attached to the Treaty of Paris. Very few people know that in the Treaty of Paris, there was a map attached. And that map included the entire Spratlys as part of Philippine territory, included here the Mapun Island, Turtle Island, and Cagayan de Cebuto. So when the U.S. Senate ratified the Treaty of Paris, they were looking at this map. And they said, okay, we agree, we approve the treaty, we ratify it. It includes the Spratlys as part of Philippine territory and all the rest of the islands in this map. Unfortunately, there was a problem. So the treaty was signed, Spain paid $20 million. What was ceded under the Treaty of Paris were the islands lying within the lines of the Treaty of Paris. So only the islands within the lines. But when in the Treaty of Paris, there are coordinates, longitude, latitude, geographical coordinates. And if you draw the coordinates into lines, this is what you get. The coordinates excluded the Spratlys, excluded Mapun Island, Cagayan de Sulu, Cebuto, and Turtle Island. So there was a problem. What the Senate approved included, they were looking at the map and it included the Spratlys, but the treaty contained the geographical coordinates. If you draw the geographical coordinates, it would not include the Spratlys. The map did not match the geographical coordinates stated in the treaty. So there was a problem. That's why when the Americans came here, the Spanish garrison in this area, Cagayan de Sulu, Cebuto, refused to vacate. They said, we're not part of the cession. If we look at the coordinates, it does not, the coordinates do not include Cebuto, Cagayan de Sulu. So the Americans had to go back to the Spaniards and said, look, we want a clarification of the treaty to that the treaty included in the cession to America, to the U.S., all other islands outside the treaty lines, because that was really the intention for the Spain to cede the entire Philippine archipelago. But unfortunately, the Americans made a mistake. They were the ones who drew the coordinates, and they were not exact in drawing the coordinates. So the U.S. Secretary of State wrote the Spanish ambassador in Washington, look, our intention was that you will cede everything in the Philippine archipelago. So let us sign another treaty clarifying that. That was the position of the U.S. The Spaniards said, we had no recourse but to sign what you dictated to us. You dictated to us those coordinates, and the treaty conveyed only islands within the coordinates. All other islands outside the coordinates were not conveyed to you because we have to follow the text of the treaty. So there was this exchange of notes, very acrimonious over time. Finally, the U.S. said, okay, we will pay you $50,000 more, just sign that the cession included all the other islands of the Philippine archipelago. The Spaniards said, no, that's too little. The Americans said, okay, we will increase it to $100,000. The Spaniards agreed, and so the Treaty of Washington was signed. The Spanish ambassador in Washington sent correspondence, telex to his Spanish minister in Madrid, and he said, there is only one article to the Treaty of Washington drawn in such a manner as to comprehend other islands outside the limits of the Treaty of Paris. So if you look at the treaty, it says, Treaty of Washington, Spain relinquishes to the treaty, to the U.S., all title and claim of title to any and all islands belonging to the Philippine archipelago lying outside the lines of the Treaty of Paris. So it included all other islands belonging to the Philippine archipelago. And it says here that those islands lying outside the treaty lines are deemed included as fully as if they have been expressly included within those lines. So it retroacted the cession under the Treaty of Washington, retroacted to the Treaty of Paris. So clearly, what was ceded included other islands lying outside the lines. All other islands belonging to the Philippine archipelago were also ceded. So the question is, what are those islands lying outside the treaty lines that were ceded? Where is that document saying that these are the islands of the Philippine archipelago? Because we have to look at the islands of the Philippine archipelago lying outside the lines. Where do we find that document or that map? We go back to the 1734 Murillo Velarde map. That's the first official map of Philippine territory during the Spanish regime. We go back to the 1808 map, Carta General, and finally the Holy Grail map, 1875 map, which is the complete map of all the islands belonging to the Philippine archipelago. So that's how we answer that question. What are the islands of the Philippine archipelago lying outside the lines of the Treaty of Paris that were conveyed under the Treaty of Washington of 1900? We look at this map. Now, the map of 1875 was reissued, adopted and reissued 4 times by the U.S. The Treaty of Paris was signed December 10, 1898. Before the end of that year, just 20 days, within 20 days, the U.S. adopted the first map, the Carta General, right after the signing. Just before the signing of the Treaty of Washington of 1900, the U.S. adopted another map. And after the signing, again, another map. And the last map was the 1902 map. So the U.S. adopted the Carta General del Archipelago Filipino 4 times. So this is really the map that says this is Philippine territory. We forgot all about this map, so we better start looking at this map now. We don't have a copy of this map, unfortunately. I've checked with all our public libraries, museums. We don't have a original print of this map. I checked with the local map collectors. I haven't found anyone who has a copy of this map. So we are on the hunt for an original copy of this map. This is the 1902 edition. This was sold recently by Barry Lawrence Rudderman. That's an auction house in the U.S. So, but now and then they do get people to sell the map because there were 4 editions from the U.S. and many might want to sell it now and then. So we're waiting for the map to appear in one of the auction houses in the U.S. But right now, we don't have an original print of this map. Now, so I asked around, if that was really the official map of Philippine territory under the American regime, did the Americans submit that map in the Islas Palmas case? Remember, there was this famous case between the U.S. and Netherlands over the island of Palmas, a very important landmark arbitration case in international law, where the Netherlands and the U.S. fought over Islas Palmas, an island in very close to Mindanao. Okay. So I've been looking for the U.S. memorandum in that case. I said the U.S. must have submitted the 1875 map to show Philippine territory at the time. And I couldn't find any until I called up Professor Batong Bakal of UP Law. And he said, oh, I went to the U.S. National Archives in Maryland and I saw it. I took pictures and he gave me a copy. And on pages 42 and 43 of the U.S. memorandum submitted to the arbitration, it says here, this map, this exhibit, is both an American official and Spanish official map. There you are. So it was submitted in an arbitration case, in the judicial arbitration. And the US said this is Philippine territory, and also Philippine territory during the Spanish regime. So a very important map. The Americans cannot deny that. So if you look at the map, Islas Palmas, this is Sarangani. So it's included in the 1875 map. Uh, but the problem was Spain was the first to discover it. But uh, Spain never returned to the island after discovering it. It was the Dutch that went to the island. The Dutch East Indies companies, they went there. There were 700 people living there, and they signed a treaty with the locals. The Dator, the chieftain, signed a treaty pledging allegiance to Netherlands. So it was submitted to arbitration who really owns it. And Max Schubert, the arbiter, said, well, the Americans submitted this official map of Spanish origin and American origin. It shows that the island is within Philippine territory. But he said, discovery is just an inchoate title. It does not give you a valid, a complete title. You must show continuous and peaceful display of sovereignty over time. And it was the Dutch that showed continuous and peaceful display of sovereignty because they went there and they got the natives to sign a pledge of allegiance, and the flag of Netherlands was flying there when the Americans went there for the first time. So the Americans lost that arbitration, and Islas Palmas is now part of Indonesia. But there's something that Max Huber left for us. He left something for us to hold on to. He said, I'm making this decision because this is an inhabited island. There are 700 people. The rule will be different if it is uninhabited. Because if it is uninhabited, you cannot go there and get the turtles and the crabs to sign a treaty with you. He said, this applies only the display of continuous and peaceful possession of sovereignty must be established, but this applies only if the island is inhabited. But he stopped there. He did not explain it further. Now, in the next case, in the 1931 Clipperton case, France claimed Clipperton Island. It was totally uninhabited, and probably you cannot live there. It is uninhabitable because there's no water there. But France one day went there in 1858, and a naval officer of France was instructed to read the proclamation declaring that Clipperton Island is part of France. It was annexed to France, and that was done in 1858. And immediately, the French vessel went to the nearest island with the government, that's Hawaii, and they took out a 2x2 advertisement in one of the journals, and the advertisement says, today France claimed Clipperton Island. And for the next 39 years, France never returned to Clipperton Island until in 1897, Mexico claimed Clipperton Island. So France went there only once to claim it and never showed up for 39 years until Mexico claimed it. And when it was claimed by Mexico, it was submitted to arbitration by King Emmanuel of Spain. And King Emmanuel said, this island was completely uninhabited. And so when France appeared, no, there were no other claimants. France had absolute and undisputed disposition of that state. And therefore, the title of France became complete upon discovery because there are no inhabitants there. You cannot go there and ask the turtles and the crabs to sign a treaty with you. So you don't have to go back to that island anymore. You don't have to show continuous and peaceful possession of sovereignty because there's no point. There are no people there. So discovery will give you a complete title immediately from the moment the occupying state makes its appearance. the title is complete because it's uninhabited. There were no other claimants. So that was the decision. And this was affirmed in the next case, Eastern Greenland. Denmark, of course, claimed Greenland, the entire Greenland, a long time ago in the 1700s. But they only populated the warmer areas, the coastal areas. They did not populate the inner areas because the inner areas were very cold. It's impossible to live there. So one day, Norway declared that it was annexing the eastern Greenland, the inner areas. So a dispute arose, and the dispute was submitted to the Permanent Court of International Justice. The court said, bearing in mind that no other claims were made by other states when Denmark claimed it in the 1700s, and that the area was inaccessible. You cannot live there. It's uninhabitable. Then, when Denmark claimed it in 1700s, it was complete. The title of Denmark became complete because you don't have to inhabit what is uninhabitable. The law does not require you to do the impossible. You cannot inhabit what is not habitable. So the mere discovery would be sufficient. Discovery and claim would be sufficient. So we go now to the Spratlys. We claim the Spratlys, the Spaniards claim it for the Philippines in 1734, in 1808, in 1875. As of 1875 and until 1933, no other state had claimed the Spratlys. And the Spratlys, according to the July 12, 2016 Arbitral Award, the tribunal said there is no historical record of human habitation in the Spratlys. The Spratlys, based on its natural resources, is not capable of human habitation. So it's uninhabited and uninhabitable. So the title of Spain over the Spratlys became complete upon discovery. That was in 1734 at the very latest, because that was included in the map of 1734, reiterated in 1808 and in 1875. And there were no other claimants until 1933. So our title to the Spratlys became complete in 1734 because the islands are not habitable. So this is the Carta General. We must value this map because this is that will show what are the islands of the Philippine archipelago lying outside the lines of the Treaty of Paris. Now, in 1938, the Philippines was already under the Commonwealth government that's run by Filipinos. And our Filipino officials at the time really had a very good foresight. In 1938, they said some country might claim the Scarborough Shoal. We better put up something there, a marker, a lighthouse. So, but they said, before we do that, let's clarify with the U.S. whether that is part of Philippine territory. So they wrote the U.S. State Department and the Secretary of War, and this is the reply of Secretary Colonel Hull, the Foreign Secretary of the U.S., the equivalent of the Foreign Secretary. He said, because of the absence of other claims, no other claimant as of 1938, Scarborough Shoal should be regarded as among the islands ceded to the U.S. in the Treaty of Washington of 1900. There you are, an admission by the U.S. that Scarborough Shoal is part of the islands ceded by Spain to the U.S. in the Treaty of Washington, because Scarborough Shoal is outside the lines. So this is an application of the Treaty of Washington, an island outside the lines belonging to the Philippine archipelago that was ceded in the Treaty of Washington. So the Americans cannot deny now that Scarborough Shoal is part of Philippine territory. They already admitted it in 1938. Now, so how do we now show to the world the Philippine territory? We cannot show them the the Treaty of Paris lines, because that has been amended by the Treaty of Washington. So the Treaty of Washington says that the islands ceded under the Treaty of Washington are included as fully as if they've been expressly part of those lines, included within those lines. So how do we cannot move Scarborough Shoal inside the lines. We cannot move the Spratlys inside the lines. So we have to draw another line to show that these are the islands ceded by Spain to the US in the Treaty of Washington of 1900. This is how we should depict it. We must lay to rest this greatest misconception in Philippine history that has misled everybody, including China. This is how we should depict it. We should have these lines because the treaty says, as included in Philippine territory, that was ceded as fully as if they had been expressly included within the Treaty of Paris lines. Now today, NAMRIA, our mapping agency, is planning to come out with this new map of the Philippines. They will draw the Treaty of Paris lines. They will draw the Calayan Island Group line territory, and here is Scarborough Shoal. So if you look at the legend of this map, they mention the Treaty of Paris of 1898, then they jump to the US-UK Treaty of 1930. They omit the Treaty of Washington of 1900. So I flagged this to them. I said, if without the Treaty of Washington, we cannot claim Scarborough Shoal and the Spratlys and even Mapon Island, Cagayan de Sulu, Cebuto. So I said, you have to put here the Treaty of Washington. I hope they do that. Now, the Treaty of 1930 with the British defines in the two whereas clauses the Philippine archipelago. Philippine archipelago is a territory acquired by the U.S. in the Treaty of Paris of December 10, 1898, and the Treaty of Washington of 1900 in two whereas clauses. So this is between UK and the US. Now Malaysia inherited North Borneo from the British. So Malaysia is bound by this treaty because they just inherited it from the British. Thus, the UK, US, and also Malaysia, a successor of UK, are bound by this definition that Philippine territory includes the Treaty of Washington. Now, in 1933, France claimed the Spratlys. China did not protest because the year before, in 1932, China protested the annexation of France of the Paracels. And China said the Paracels form the southernmost territory of France. So 1 year before 1933, China said our southernmost territory are the Paracels. So when France annexed the Spratlys, China couldn't say that, oh, our territory includes the Spratlys, because they already said the year before that their southernmost territory. They cannot move farther south because you have to cross the South China Sea high seas before you reach the Spratlys. So China was quiet when France annexed the Spratlys. And as I said, France claimed the Spratlys on behalf of itself, not on behalf of its colonies. And when Vietnam claimed the Spratlys, saying that they inherited it from France, the French made it clear. They issued several notes verbal saying that beyond doubt, the Spratlys belong to the French Union, not Vietnam. They said, no, we did not claim it for Vietnam or for any other Indochina colony. We claim it for ourselves. That is the defect of the claim of Vietnam. They cannot claim it as the successor of France because France did not claim it on their behalf. Now, China issued this 3-volume atlas of ancient maps in China. All the ancient maps of China since the beginning of the dynasty until the last dynasty, the Chinese dynasties ended in 1912. The last dynasty was the Qing dynasty. So these are 3 volumes published in 1990, 94, and 1997. And in these maps, ancient maps of China, in all these ancient maps of China, Hainan was the southernmost territory of China. So you have this Song Dynasty map, Hainan as the southernmost territory of China, Yuan Dynasty, the Mongol Dynasty. Hainan is the southernmost territory. You have the Ming Dynasty. This is Hainan as the southernmost territory. And finally, you have the last dynasty, the Qing Dynasty, Hainan again as a southernmost territory. These are all in the Atlas of Ancient Maps of China, an official publication of the People's Republic of China. They cannot deny that these are the official maps of the Chinese dynasties. And so what is the legal value of these ancient Chinese maps? As a rule, maps do not establish sovereignty over territory unless attached to a treaty. So if there's a treaty between two states saying that the attached map shows the territory of state A or state B, then that is binding. But there is an exception. If a map is unilaterally produced by a state, even if it's not attached to a treaty, it can bind the producing state if it is adverse to its interest. So in the case of Pedra Blanca, this is the arbitration between Malaysia and Singapore. The tribunal said, the ICJ said, the map still stands as a statement of geographical fact, especially when the state adversely affected has itself produced and disseminated it even against its own interests. China produced these ancient maps in China and disseminated it against its own interests. So China is bound by those maps. It is an admission by a party against its own interests, and that is binding. That's the rule. You are bound by an admission against your own interest. In 1932, France seized the paracels and announced it to the world. We are annexing the paracels. So China protested. China made this protest in 1932. China said, the paracels belong to China, and they form the southernmost part of Chinese territory. 1932, China said, our southernmost territory are the paracels. That is an admission that China did not own the Spratlys and Scarborough Shoal, because the Spratlys and Scarborough Shoal are very far. These are the paracels. Scarborough Shoal is 326 nautical miles. The Spratlys are even further, 405 nautical miles. So by their own admission, China said, our territory is up to the paracels only, 1932. That's binding on China because it's an announcement to the world. In 1943, China published the China Handbook. This is under the Kuomintang. China was still under the Kuomintang at that time. And the China Handbook was an introduction of China to the world. And when you introduce your state, the first thing you do is to state your territory. Chapter 1 of the handbook says, the territory of the Republic of China in the South China Sea, our southernmost territory is Triton Island of the Paracels. So 1943, we're already in 1943, China has not yet claimed the Spratlys and Scarborough Shoal. Their southernmost territory was Triton Island. 1943. Now, they revised this handbook in 1940. That's the handbook. They revised this in 1947. And in 1947, for the first time in Chinese history, they claimed the Spratlys. They said, the sovereignty over the Tuansha, that's the Spratlys, on the south are contested among China, the Commonwealth of the Philippines, and Indochina under the French. So in 1947, for the first time in its history, China claimed the Spratlys, but admitted that the Philippines also claimed it. So that is a fatal defect because China was claiming a territory that was the terra nullius. You can claim a territory if it is terra nullius. It doesn't belong to anyone, but they admitted, oh, the Philippines had already a prior claim. So it was a defective claim, inherently defective claim. But the fact is, China claimed it only for the first time in 1947. That's the book. In the San Francisco Peace Conference, China did not participate because there was a civil war. Neither the Kuomintang nor the Chinese were represented. So the USSR, as the ally of China, made a motion to award the paracels and the Spratlys to China. That motion was defeated by a vote of 46-3 with one abstention. So very clearly, the San Francisco Peace Treaty rejected to award the Spratlys and the paracels to China. Now, if you go to TikTok, you will see Filipinos saying that the Japan-China-Taiwan Treaty of 1952 awarded the paracels and the Spratlys and Scarborough Shoal to China. It's impossible because in the 1951 treaty, Japan renounced its claim, period. We renounce our claim to the Spratlys, to the paracels, period. It did not award because the conference refused to award it to any country, refused to award it specifically to China. And there was another treaty signed by Japan because the Americans wanted Japan, and the Republic of China then was representing at the time. It was still the representative in the UN, in the United Nations, wanted a peace treaty between Japan and the Republic of China. So this was signed in 1952. But then that treaty just mirrored the San Francisco Treaty. It is recognized that under Article 2 of the Treaty of Peace of Japan in San Francisco, Japan renounced all right and title to the Spratlys Islands and the Paracel Islands, period. There was no award to China. So it just mirrored the San Francisco Treaty. And not only that, the San Francisco Treaty took effect more than 3 months prior to the effectivity of the Taipei Treaty. So when the Taipei Treaty took effect, the renunciation of Japan of the paracels, the Spratlys, already became final. There was nothing for Japan to transfer anymore to China. And the intention really was not to transfer it to any state. So it's very clear, but we have a Filipino group, Vocally for China, citing the Taipei Treaty, that the Taipei Treaty awarded the Spratlys to China. Of course not. The San Francisco Treaty takes precedence. It was signed ahead. It took effect ahead of the Taipei Treaty. So the China did not participate in the arbitration at The Hague. But China said, we're not participating, but this is our position. They said that Philippine territory is governed by the three treaties pursuant to its 1935 Constitution. They mentioned again the Treaty of Washington. So they admitted that Philippine territory includes the islands ceded to the U.S. by Spain in the Treaty of Washington. Because they mentioned the Treaty of Washington, that Philippine territory is regulated by 3 treaties. And of course, they did not read the text of the treaty because they just relied on Filipinos who said Philippine territory is limited to the islands within the treaty lines. But they are bound by this admission. This is a judicial admission because they said we're not participating, but this is our position. And the tribunal said we will treat your position paper as your comment. So this is a judicial admission by China that Philippine territory is governed also by the Treaty of Washington. And judicial admission is the highest form of admission. China cannot get out of that. They already admit that Philippine territory is governed by the Treaty of Washington also. So it's really a judicial admission, the highest form of admission. And China is forever stopped from claiming that Philippine territory is limited to the islands enclosed by the Treaty of Paris lines. So the last issue to be resolved is, did the U.S. or the Philippines ever abandon its claim to the Spratlys or Scarborough Shoal. You go to the timeline, there was never an abandonment. Uh, in fact, in 1935, we included that in our constitution. The moment we included that, then it could no longer be detached by the U.S. because under the uh, legal consequences of separation of Chagos Archipelago from Mauritius, the colonial power cannot detach a territory that is already part of their colony. And in 1935, we already said those three treaties define Philippine territory. And there was no abandonment at all. In 1946, when we became independent on July 4, the UT Possidetis Juris principle applied already. All states will have to follow that already. Now, China only claimed the Spratlys in 1947, too late the hero, because the UT Possidetis Juris principle took effect already July 4, 1946, when we became independent. China claimed the Spratlys a year later, 1947. And so there is really no abandonment. Vietnam occupied it only in 1975. That's way beyond the critical date. So, conclusion, we have to bear in mind and tell everybody, tell our people that our national territory is governed by three treaties. They are fortified by the UT Possidetis Juris principle, and we must show to them the 1875 Carta General del Archipelago Filipino as proof that the Spratlys and Scarborough Shoal form part of Philippine territory. So my recommendation is we challenge China, Vietnam, and Malaysia to submit the territorial dispute in the Spratlys to voluntary arbitration. Separately, we challenge China to submit the territorial dispute in Scarborough Shoal to voluntary arbitration. If they refuse, we will go to the court of world opinion. We'll explain to the world, we have all these records, we have all this evidence, we have all these doctrines of international law. We have the strongest title.
Wow.
We have to change the perception because of what our legal luminaries said, that Philippine territory is limited to the treaty lines, all islands within 3 lines. If you look at the foreign journals, law journals, they always say the Philippines is the weakest claim because they start with, in the 1970s only, they start with Tomas Cloma. I never mentioned Tomas Cloma. We start with the 1734 Murillo Velarde map. I end my presentation here. Thank you for your patience and kind attention.